on WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
That's us, WDXE, and I have Mr. Stan Pierchoski in here. It's his turn.
You do have Mr. Stan Pierchoski in here this time. Good morning, Jeff.
And the mics are working, so that's good.
Oh, good.
I reckon so.
I can be loud if I have to. So.
Well, we'll be good. We'll be good. You might pull it up just a little closer to you, and then we'll keep it.
All right.
There we go. So how have you been since our last visit?
Been good. Been busy. I have a wedding happening tomorrow.
Oh, really?
My son getting married tomorrow. If he doesn't get here soon, I swear it's going to kill me. The to-do list has been, well, you know.
Now, where are they getting married?
They're actually getting married over in Pulaski.
Oh, in Pulaski.
And
okay.
they're having the rehearsal at the Star Theater. I mean, the rehearsal dinner's at my house tonight.
Yeah.
And, of course, it has to look just
well,
right.
Yeah, it has to be perfect.
In multiple levels.
It has to be perfect.
And then they're going to do a reception at the Star Theater on the Square after the wedding tomorrow.
Oh, nice.
So like I said, my bones will hold out. I'll be all right if I can get past Saturday, I guess.
At least you're not having to travel.
Well, we were putting stuff at the theater, and we have a nice scaffolding. But you know what the problem with scaffolding is? You find yourself going up and down it like 100 times.
Oh, my gosh.
I left one night about 8:30, and I thought, if I have to climb the scaffolding one more time, I'm just going to cry. But we'll get there. We'll get there.
Excuse me. Excuse me.
Yeah, but and guess we have the rehearsal dinner at the house at 4:00, and guess when the rain's supposed to come?
Right about then.
It's just a blessing. That's all you can look at. It'll work.
It'll be fine.
It'll all work out.
When my daughter was getting married, we had an outdoor wedding planned, and we were able to do it. But the weather began to turn on us just a little bit, and it threatened, and actually began to just sprinkle just a little bit before the wedding. And my daughter looked at me with almost tears and said, "Daddy, is it going to rain?" So I had to pretend like I had complete control and told her, "No, honey, it's not going to rain. It's going to be fine." And it didn't. Thank the Lord.
The Lord has impeccable timing, does he not? The Lord has impeccable timing.
Yeah.
He knew if he held off just a little bit, he'd be all right.
Yeah. Yeah. So
and
anyway.
you know what's wrong with getting married in the rain? You know.
Yeah. I guess if it'd been raining, we'd have been married anyway. So there you go.
No, I remember one time when my wife and I first got married. Before we had children, we were at Disney World.
Oh yeah.
You know how you stand in lines at Disney World, right?
Oh.
We were in this line for something. I don't remember when. It was a summer afternoon, and the line was really, really long. And so we're standing in it, and a thunderstorm decided to brew up.
Uh-oh.
Well, it started to rain, and everybody ran. But we thought, we've been in this line for like 20 or 30 minutes now. It's got about another 20 or 30 minutes to go.
Right.
So we just kind of held each other close and just stood there in this
Just toughed it
downpour
out.
torrential and just kind of laughed. I thought it was pretty funny.
You just say, we'll just stay with it.
The weight was mightier than the rain.
There you go.
Anyway. Hey, listen, we have a seminar coming up. It's going to be here. The next
really?
one. I told you we were stretching them out a little bit, but
Yeah.
the girls have scheduled it for one reason or another, but it's not going to be till May.
Okay.
It's like 2 months out.
Okay.
May the 18th.
Which will be here before we know it.
Oh, it will.
Yeah.
It will. But it's May the 18th, which is Saturday. We'll do another one here. And because we're embarking on our, where we're going to stretch them out a little bit. Because we
Yes.
go to just so many different places. And we'd asked to do private ones at churches and businesses and stuff. So
Right.
I got to have time to do my work. So
Exactly.
But the one we had here a week or two ago, or last month in February, was a great one, man. It was very well populated. We're still dealing with some people that had come to that are scheduled meetings and stuff. So we stay scheduled out pretty much toward the end of April almost.
Okay.
So anyway, that's coming up. I'll talk about that more as we get closer.
Yeah. Yeah.
Stuff like that. So one of the topics I wanted to bring up this morning, I like to have some things to talk about on this that especially based on things that come up or we see happening in this estate planning world. First of all, I want to remind folks, if you want to call, don't forget, we had a couple calls last week. And if you want to call, just give us a ring here at the WDXE radio station, which is 931-766-9393.
Yes.
Kind of an easy number to remember. And ask. It doesn't even have to be about what I'm talking about. If you want to ask a question or if you want to share an experience, that's cool.
Yeah.
We
do invite the phone calls.
Those are good because it gives us real life stuff. You know what I mean? I can talk about some of this stuff in theory all day long, but the stuff that you really get to where rubber meets the road when you hear about what happens to people, what they run into.
A real life situation.
And stuff like that. So feel free to do so. But what I want to talk about is this happens. I've been wanting to talk about this for a while because it happens a lot, and we kind of see it mostly in our incapacity planning or our TennCare planning. But sometimes we see it after death, and that is this: if you're like a parent and you're naming your children as your agents for power of attorney, if you become incapacitated, or you're naming them as successor trustee or executor of your will, one thing we find that people don't do a very good job of is letting their heirs know what it is they own, what they have. Because it's now after death, it's an issue, but there's not much timing involved. So we have to figure it out, but we're not under the gun to figure it out. But when we're getting somebody prepared for TennCare, we have to disclose all assets or do something with them to change them from countable to non-countable for the eligibility process. And usually, hopefully we're not paying $9,000 a month while we're trying to do all this, and if we can't find things or things just pop up out of nowhere, it delays that. Okay, so it happens a lot. People they find something and they say, "I had no clue Dad had got this annuity that he's got, or something like that. It's got it 30, 40 years ago. I had no clue, and I had no clue that it even existed." Well, it's an asset we got to deal with.
Right.
And sometimes when we're doing that, the worst that can happen is TennCare contacts us and says, "Hey, we found this CD.
Yes.
Tell us about this that's in your client's name." It's like, and I go to the family and it's like, I didn't know he had a CD. I don't know what they're talking about.
Yeah.
We look into it and sure enough, there it is and stuff. So it works both ways. So if you are a parent and you're naming folks as your fiduciaries, let them know what you own. Now, you don't have to give them dollar amounts in the bank accounts, just what kind of asset they have. Say, hey, I got a CD over here at the Bank of Frank Ewing. Or a couple. I've got a checking and savings account at this bank. I got an Edward Jones or a Raymond James kind of investment account. That kind of stuff. Let them know what the asset, but you don't have to give them the details and amounts if you don't want to. But at least they know where to look, when that happens. Because, I think I've mentioned this before, when we're dealing in a TennCare eligibility situation, let's say we find an asset with Raymond James or Edward Jones or Morgan Stanley, one of those managed accounts, right? Well, we have to go to them to deal with that money.
Right.
And the first thing they're going to do is say, "Who are you?" And we're going to say, "Well, I'm the son of my dad, who we're getting qualified for long-term care, and I'm his power of attorney." And they're going to say, "Well, before we even talk to you, please send us a copy of that power of attorney." Okay? We're dealing with insurance companies, all right?
Exactly.
And they are difficult. And so they say, "Send us the power of attorney." And so they give us 7 days to whatever they do with it, scratch it, sniff it, determine how they like it. And then after 7 days, they'll say, "Okay, we accept the power of attorney. What do you want to know?" And so we say, "Okay, he has his account. How much is in it? What's the posture of it? What kind of an account is it? And they tell us all this, and then we'll say something like, "Okay, well, we need to cash this out so we can convert it into something else." Okay, we'll send you the surrender forms. Give us 5 to 7 days to send you the surrender forms, and so they do. And then we say, "Okay, here's the surrender forms. We submitted them. Okay, give us 7 to 14 days to cut a check, and then mail it to you."
Yeah.
Then you get the check. You go to your bank to deposit it in his account. They say, "Give us 5 days for this to clear." It's coming from an insurance company. What are the chances it's not going to clear? But, so next thing you know, we have got a month tied up dealing with this financial institution. And if we'd have known we had it, what I advise people, I'd say, listen, if you know you have these and you've given power of attorney to your kids, let's go ahead and send them the power of attorney now. They're not even asking for it. Let's get it on file. They will review it and approve it. So if the time comes, we just pick up the phone and we've got to get that first time period resolved.
Yeah.
So, if you're a parent and you have kids that are your fiduciaries, let them know the kind of stuff you have. If you are the child or the adult child that's the agent or beneficiary, ask your parents to reveal that to you.
Yeah.
And just explain to them that this will really save a lot of time and a lot of money if I know a little bit about what you have. And like I said, you don't have to tell them. I'm not trying to get real nosy. If you have a CD, tell me you have a CD and where it is. If you don't want to tell me how much the CD's worth, don't. We'll find out in due course of time. But if it's a scavenger hunt, and if we miss an asset during eligibility, and TennCare wants to play hardball. Now, a lot of times they will give us an opportunity to deal with it. Okay, but if something surfaces that we overlook, that could disqualify us. It could have derailed the entire effort.
Yes.
And that's not a good day when that happens. So there are ways to recover from that, but it's a lot. We got to do a lot. So it's best to know everything that we own, and so we can deal with it. And when you think about it, the list is really not that long. I mean, it may be longer for some, but you got real estate. There's no problem. We know what they own when it comes to that.
Right.
There's just rarely does we find out that, hey, mom and dad had a piece of property, I didn't even know about it. You know?
Right.
Maybe things like timeshares and stuff, which is kind of quasi real estate ownership, but you got real estate. You have money in the bank in some posture or another. Okay, maybe you've got some stocks and bonds, but if you have stocks and bonds, rarely do people still have the actual certificates. They usually own, they own bank stock, and it's with Raymond James or something like that. So it's easy to liquidate when we have to. You don't actually have the physical certificates.
Right.
Some folks do, but for the most part, that's not the way it is. So it's very helpful when this comes. So it's a good idea to do that. To be a little.
Yeah, I can see that even in my own circumstance. I've probably got things that I've dealt with just because I'm in business for myself. That my wife, not that I'm hiding anything, but she may not know that I've got this over here and that over there, and those kind of things.
Yeah, you just have it and don't
think about it.
Forgot it or don't bring it up.
And then God forbid if something happened to both of us, then our heirs may not have a clue where we have anything.
Yeah. Like after death, somebody's figuring out, okay,
Yes.
what I need to do. It's like, well, when I used to do probate, I would say, well, you need to accumulate all the assets so you can get charged them all. And so how do I know what they have? Well, one way, if just kind of look over their mail for the next month or two. Mm-hmm. When you get something in the mail from, Mutual of Omaha or something, where your parents get, or the deceased gets something in the mail from them, open up and take a look at it and see what we got. And if it looks like it's something that is an asset, like if it's a life insurance policy, it's only an asset if if it's whole life and you have a cash surrender value. If it's term life, it's just a death benefit where you have no ownership. And so, but if it is, we can look at it and see and decide whether it's something to look into or not. And again, when you're doing it that way in an after death scenario, the clock is not ticking on you.
Yeah.
You have time to deal with it. But, when that happens, when we're doing eligibility, it gets pretty tense.
Yeah. When my parents passed, they didn't pass all that far apart, but my dad passed first, and then mother kind of had charge of things. And she did a very good job of letting us know what her wishes were and where things were. And even with that, there were questions after her death that we were like, okay, well, what is this? Is this everything? Are we sure we got it all? Because you just didn't know,
Yeah. I'll tell you something else when you're dealing with these third-party financial institutions.
Yeah.
Sometimes I just haven't got a clue what they're going to do.
Yeah.
We had one recently where we're getting the mom ready for TennCare. And there was a little dinky $1,000 insurance policy. It had a surrender value of $1,000.
Yeah.
Okay,
Yeah.
exactly. And it was something she had bought for her sons and paid off. And one of the sons died during COVID, okay? And so we were wanting to cash this thing out because it represented an asset.
Yeah.
We can only have so many countable assets, and that was a countable asset. And so we got it. So we're trying to get them to send it to us so we can take the $1,000 and convert it to a non-countable asset so that we can get eligible. Now, they wanted, I'm trying to remember what they wanted. They wanted a HIPAA waiver, which I questioned for the deceased because I'm pretty familiar with HIPAA.
Yeah.
And medical records, they're not as strict with HIPAA.
Now, for those of us who don't know, what is HIPAA?
HIPAA is the Health Insurance Portability and Accountability Act. What that means is your health records are private.
Yes.
So if you don't believe me, Jeff, just call the hospital or your doctor and say, I want to talk to you about my wife's x-rays. And I want to talk to you about my wife's test that she had today. Now, you may have something on file that waives but you're going to run into this Chinese wall called HIPAA.
Yes.
And they're going to say, no, those are private. And you're going to say, but I've been married to her for like 45 years.
Yes.
And they're going to say, sorry.
Yeah.
That doesn't mean anything. HIPAA says they're private. And so, and they won't give them to you. They just won't. And here it's a liability issue. If they give them to you when they're not supposed to, they can be sued.
Yeah,
and
absolutely.
They fail closed when that happens, okay? Now, so, they wanted this HIPAA waiver for the deceased. And, of course, there wasn't one. And the only person who can sign a HIPAA waiver is the person that's waiving the right to privacy. See, when we do our trust plans, one of the things we do, we do a health care power of attorney. And right along with the health care power of attorney, we do a HIPAA waiver. And what it is we say, okay, whoever's acting under this health care power of attorney for you, whether it's your spouse or your children, it's not really an order thing. It's whoever's acting on the document we just signed, which was the health care power of attorney, if they're acting as your health power agent and they want to see your medical records to help them make a good decision for you, okay? Now, spouses pretty much know each other's history, but the kids maybe not so much.
Yeah, that's right.
And if they want to see it, they can run into HIPAA. So what we do is we sign this HIPAA waiver, and it says, whoever's acting of my, all these people that are named, I'm waiving my right to privacy under HIPAA so that you can issue them the health records and they can see it. Now, that cures it, okay? Now they'll give it to them. And when you think about what's actually going on, now it's okay for them to give it to them because now they can't get sued for giving them to somebody else.
Right.
You have waived your right to privacy under the HIPAA Act and allowed those people to see it. But if you don't have that, now, here's the situation we had. They wanted a HIPAA waiver to disclose some kind of information with this dinky little $1,000 cash-in policy
Right.
before they would distribute. And it's like, okay, I'm pretty good. I think I'm pretty smart. But maybe you should explain to me how I'm going to get a HIPAA waiver signed by the deceased, who's the only one that can do it.
Yes.
And before you say it, don't tell me their power of attorney can do it because power of attorney expires at death. Okay, so don't even suggest that like you're going to.
Yes.
Legally, we can't do that. Okay, so how am I going to get HIPAA waiver of a deceased person if there wasn't one that existed during the life?
Yes.
And I checked with the wife, and that was not a fun conversation to have to ask her that. And so, and she said no, there wasn't one. So it's like, so here, my thought was this, never will I take the position there's nothing I can do. So I thought, okay, we may never get that, but I'm on the outside that $1,000 is found by TennCare, and we have to disclose everything. Yeah, that's a countable asset. You're only allowed to have less than $2,000 of countable assets. So I thought, all right, we will just make sure that when we get all done, after we convert all the assets to a non-countable asset, we'll make sure that there's maybe $0 to $500 in that bank account, so that if that $1,000 ever surfaces, we'll just put it in that bank account and we won't be over the limit. So I kind of made room for it is what I did. Well, surprisingly, we were getting very, very close. We were just days away from actually filing the application. And the POA come walk in my office and said, hey, I got the $1,000 check from Aflax or whatever it was. And it's like, it just magically appeared. I mean, we gave up on it about a month before trying to get it. We just thought, this isn't going to happen. I can't bridge the gap. Yeah. And so, but the insurance company just decided to send it. So, it makes me wonder, how important was that requirement that they told us, you can't do anything. We have to have this HIPAA waiver. If you can't get it, we can't distribute the money. That's how important it was on one conversation. A month later, the check magically appears in the mail.
It's just part of that insurance and or government bureaucracy.
And it is form over substance. I mean, if it was true substance, it wouldn't never yield it, right?
Yeah.
It gets old sometimes, but
sometimes
you never know what they're going to do.
Sometimes with those circumstances, it seems like common sense is just out the window.
Oh, reason, logic, and common sense is a superpower. I swear to gosh, it is. And sometimes in situations like that, it just doesn't feel like they have much of it. But I don't know. But we got by it, and I guess we could have eventually, got the $1,000. We weren't worried about the $1,000. We were worried about the $1,000 surfacing and pushing us over a limit that we're not supposed to go over.
Right.
So I figured out a way to work it in there, and then it appeared, and so we ended up just converting it to a non-countable asset. And we managed to save a ton of property.
Perfect.
Hundreds, over $1 million worth of property saved and get that person qualified. So
good deal.
And we wanted to save that family farm because we had two families that were relying on it that worked it. So that was goal number one. And that's completely saved.
Awesome.
Happens. That kind of thing happens a lot around here, saving the family farm.
Yeah.
Now this was a true 11th hour thing.
Yeah.
Well, but that happens sometimes too. So
yeah.
But it was. I forget how we got on that, but we were talking about.
You're talking about that.
Dealing with third party.
Dealing with the third party and the HIPAA.
Yeah.
And then the regulations that they're under and we're under, I guess.
And that would have been a classic case where had this person done a trust plan with me, they would have had a HIPAA waiver already on file in their documents that we could have just scanned and sent right to them that very day.
You kind of skinned over something there too that I deal with sometimes, or at least comes up in my little world, is the power of attorney. Mm-hmm. And the fact that, and you may or may not, some people may or may not realize it, that the power of attorney ends at death.
It does.
So that something else takes over at that point.
That's right. Now, really, the good way to think of it is, during life, you have power of attorney, you're making decisions for that person.
Yes.
A good way to think of it is this. You are standing in the shoes of the principal. So
Yes.
if you're your power of attorney for your wife,
Yes.
you are standing in her shoes, making the decisions that she would make if she could make them. Okay?
Yes.
So you don't say, it's like a lot of people say, I don't want to give my kids power of attorney because they'll spend all my money. I say, well, that's not how it works. If you're a power of attorney, you don't go buy yourself a brand new car
No.
with dad's money. So if you're standing in his shoes and do what he would do if he could do it, would he buy you a brand new car? Probably not. So that's how you determine if you're doing a fiduciary duty or breaching a fiduciary duty.
Right.
Now, if you've got a house and the electric bill is due, and dad always pays the electric bill, well, you see how the standard works.
Yes.
Then pay the electric bill because he would be doing that. And the other side of the coin is whatever you do as a fiduciary is always in their best interest.
Yes.
So you're making these decisions and doing anything. Now, at death, there's really no decisions to be made anymore.
Yes.
Okay? As far as life, okay, the decisions now are distribution of property and stuff like
Right.
that. And so at death, what picks up now, it switches, your powers change. Your power of attorney expires at death, and if you have a will, you're appointed as the executor of the will. Okay,
Right.
and then you have the court gives you the authority to deal with property.
Right.
If you don't have a will, then you're sworn in as the administrator of an intestate probate. Then the court gives you the authority to deal with the property. And if you are a successor trustee, which is the after-death trustee of a trust, you don't have to go to court. You've already got the power to deal with all the property. And so now the power shifts to that power, and now you have the authority to gather all the property. You're the one that the property custodians have to deal with. Like, so if we go to the bank account, if you go to the bank and say, I want to put this bank account in this state account where I'm gathering everything, the bank will recognize that authority for you to do that.
Yeah.
Okay? But you're not making decisions for this person anymore. It's a slightly different power.
What's that title again? If you're go through those titles again. You got the power of attorney, and then that ends, and then
Okay. Then the after-death power
Yes.
is going to reside in a couple different ways. If you have a will,
a will.
a good way to think of it is like this: a will needs to be executed.
Right.
Therefore, there you have the person called the executor.
Right.
And for female, it's executrix.
Yes, it is.
Now, if you don't have a will, your estate has to be administered. So you have an administrator, and you could have an administratrix. Hard to pronounce.
Administratix.
Yeah, administrator for a intestate estate. Now, if you have a trust, you have somebody called the successor trustee, or like I said, the after-death trustee. So at death or at the second death of a couple, the successor trustee now has the job
Okay.
of distributing property.
There you go. I'm learning my terminologies.
Yeah.
So-
Here's another difference between those. If you're an executor or an administrator, you are not that person, you are not that job, or have any of those powers until the court says you do.
Okay.
You're sworn in, and when you're sworn in as the executor, you get letters testamentary. When you go to the bank and say, I want to take over this account, they'll say, do you have letters testamentary, which is the documents from the court saying you are now that person with that power. If it's intestate, you get these letters of administration.
So even if there is a will, if there is a will and you are named as the executor in that will, you still have to go to court to
Absolutely.
get to get the stamp of approval, I guess, which is the letter of testamentary.
Absolutely. A lot of people say, I'm the executor of Dad's will. You're not really
Yes.
the executor until the court swears you in and says so. And if
Yeah.
you're not a good person, they'll try to find someone else.
Yeah. Let's see if someone wants to talk to us here just a minute. Hey, good morning. You're on WDXE with us.
Is this a radio station?
Yes, sir.
No, sir. This is a ma'am you're talking to.
Oh, I'm sorry.
Have y'all done the birthday clubs?
Well, hon, we don't do the birthday club. We just wish happy birthdays. The birthday.
Oh, well, okay,
Yeah.
well, whatever. I didn't know.
Yeah.
But does the other one do? Is it already done or what?
I don't know. You may have to dial that number. It's 762-6200, okay?
Hey, Brother Jeff,
Yeah.
that is my birthday.
No, it ain't tomorrow.
Oh, yeah, tomorrow's my
All right. Well, thank you, guys.
birthday. Okay,
Bye-bye.
God bless you.
Bye.
Bye-bye. Yeah. How about that?
Yeah.
That's a regular listener, Mr. Nolan Perry down there. Happy birthday.
yeah.
We'll wish him a happy
That's
birthday.
right.
Happy birthday to him.
Very much so.
But he does listen to us a lot. He comments on the shows every once in a while.
Oh, okay.
Sure
Yeah.
does.
Well, I hope it's helpful.
Yes, indeed.
It does make me try to remember my train of thought now. Oh,
Yeah.
executor and executive.
Yeah, we were
administrator.
going through these terminologies here.
Yeah, months after death, you could become the executor. And before, here's where that becomes a problem. I'm sure you've heard of this, being in the real estate business. Somebody passes away.
Yes.
And the estate's not opened yet.
Yes.
I mean, you don't go the day after death and open a probate. I guess you could, but typically it's not done for a couple of months, usually. And you have people that go in the house and take stuff and walk away. I mean, family members, not strangers necessarily. But
I've heard some stories.
And somebody says, well, I need to go change the lock, or they call the police. Now, let's say you're named the executor in the will, okay? And you call the police and say, hey, the police are going to say, you need to show me your authority that you're the one that has standing to prosecute this.
Yes.
And they haven't got it.
Yeah.
They don't even have the authority to change the locks to keep the pilfering from happening.
Wow.
So, but once you're sworn in and the court gives you letters testamentary, now you are that role that has power.
Yes.
But until then, you don't have it. I mean, if you're named the executor in Daddy's will, you're not the executor until they say you are.
Right.
And that's a disadvantage sometimes. Now, as opposed to the successor trustee, who has even more power than an executor in will, because successor trustee is the successor trustee of this trust, which does so much more. But that title and that power exists the moment of death.
Oh, okay.
I mean, if somebody wanted to start dealing with assets the day after death, they have the authority to do it.
Okay.
And it's not doesn't come from the court. It comes from our trust code.
Yes.
And we name somebody in the trust now during life.
Yes.
So if you name your son, the one that's in here from time to time, that at your death you want him to be the successor trustee, that job title, that job position will become a reality at the second death between you and your wife, and he will be in it, and he will be instantly in power and authority to deal with property. So he can, if something's happening like that at the house, he can lock it down. He can have them arrested. He has the authority to do all that immediately. So yeah, it's
a big advantage. It seems to me.
It is, and it makes things go quick too. The administration of the trust, which is the property distribution, it can start as soon as possible.
Yes.
Hopefully they'll mourn for a little while before they start distributing property, but who knows?
Yeah.
At least they can. They'll probably mourn for a couple of months at my wife's death, but for me, probably a day. It's okay. Let's get the stuff.
Are you saying Trace and I always make fun? We were poking at each other about something like that. We're like, who's going to be your date at my funeral?
Oh, that's rough. Yeah.
So anyway, we've had a long time good relationship. We've been married too long.
Yeah. How many?
Teresa and I have been together since 1979, so we were about 44 years.
Very good. I'm at 36.
Yeah. Yeah.
So I was in 1987.
Yeah. How about that? Yeah. So she's put up with me a long time, and bless her heart, she's still with me. So
yeah, there
you go.
I know. It's amazing. Sometimes I say the only flaw my wife has is she has terrible taste in men.
But hey, we've had a pretty good run. I think we're going to make it. We're going to try.
There you go. That's right. We're going to make it now. So
let's try another phone call. Let's see if we got the phone ringing. Let's see who's talking with us now. Hey, good morning. You're on WDXE with us.
Yeah, I have a question.
Okay.
I have no children, never been married. I have siblings, but they're not really well physically, and they don't want to do it anyway. I don't really have anybody to be an executor of my will, per se. What do you do in situations like that?
Well,
okay.
I think he and I both could probably answer that, but I'm going to let the attorney answer that.
Okay, let you have it.
Okay, I'll hang up.
All right.
If you want to take a crack at it, that's fine. But
well, I just had a real life example of this.
Sure,
I really did. A real life example.
And I will quiz you.
A very, very good friend of mine passed away. I'd known him for 38 years, and we just had his estate sale, and we had a mutual friend who was a banker, and he appointed, and he had his ducks in a row. He went and seen a lawyer. He had all his stuff done, and he just appointed someone that he personally trusted, was not a family member. He left his estate to someone he wanted to leave it to that was a distant family member, but he had an executor of this estate that handled everything. And he even laid out that he wanted us to handle his sale. So she needs to consult with someone who can see that her specific wishes are taken.
That's one route. I think the question she was asking, what happens if she doesn't have anybody to put in that? Or
That's-
in other words, your friend picked somebody.
He did.
What happens if I don't have anybody to pick?
Yeah.
And the answer is this, and it may not be the answer you want, but I've never been one to, try to blow smoke up somebody's, and let them know that, give them the sugar-coated answer. What will happen is if you do have a will and you just void in naming an executor, that it is a vacancy. And the only person that can fill the vacancy in an executorship is the court. And they will. They'll pick somebody. Now, who they'll pick, I don't know. They will look for, people. Some people can throw their hat in the ring if somebody wants to. Let's say you have a good friend that will say,
Yes.
look, I'll do it. I'll throw my hat in the ring. I'll be the executor.
Yes.
But if nobody does, the court will pick somebody. And if there's nobody to pick from, they will pick a professional.
Yes.
They will pick an attorney, or they will pick
Yes.
maybe the trust department of a bank or something like that.
Right.
Now, that happens sometimes I have clients who want to do a trust, and they don't have children, and they really have nobody to make it the successor trustee.
Yes.
And, all banks, or most of them, banks are no strangers to trust law. They know how it works, and most banks have a trust department.
Right.
So you can name a trust department as your successor trustee.
Yeah.
And the good news about that is, those, they're corporations, so they kind of like never die.
Yeah.
Oh, they're always going to be there.
Right.
The good news is they will do exactly what that trust says to do, no more, no less, to the letter. And they won't put up with any whining from people that you're leaving property to, if there is any whine. They'll,
Yeah.
The downside is it's a compensated position. They get reasonable compensation, which is not bad. But,
Yeah.
But so there is a way.
Yes.
You can do the same thing with the executorship. You can name a professional.
Right.
So if you want to name an attorney or somebody, I'm sure they will want something in the will saying that the executor is entitled to reasonable compensation. Reasonable means a reasonable fee
Yeah.
per hour and a reasonable number of hours.
I had dealt with an estate where he had spelled out in his estate how much he wanted that person to be compensated.
Yeah, you
Can
can do
that be
that.
done?
Yeah, you can do a couple of things. You can say a reasonable compensation, which kind of leaves it open.
Yes.
You can say no compensation, which
Yes.
is none. And a lot of times when people name their adult children to do it and they're getting a portion
Yes.
of everything, they say no compensation.
Right.
Unless unless they anticipate it's going to be like really complicated.
Right.
Okay. Or you can say a specific compensation. And that when
Right.
you say specific, now it can be either a percentage or a dollar amount
Right. Right.
or something else. You can say.
Yeah, absolutely.
You get 5 of those gold eagles in the safe, or you pay, or you get $10,000.
Yeah.
Or you get 1% of whatever.
Right.
The percentage is difficult because it kind of moves, but then if you give a lump sum after 20 years, it doesn't sound like much. It sounded like $5,000 20 years ago sounded like a pretty good fee.
Yeah.
Now it was like, okay, it needs to be more than that. So, but there's all different ways you can do that.
What strikes me about this, Stan, is if someone will go ahead and address these things with you or someone like you and get it and get it all lined up, they can make all those decisions and make an informed decision. And even if they're in the circumstance like that where they don't have immediate family or someone who they feel like it, at least they can get some good advice on what will take place and what can take place.
Now, there's another. I hope we answered the caller's question because she was kind of thinking, "What if I don't have anybody to name?"
Right.
If you don't have anybody to name and you don't name anybody, that vacancy will be filled by the court.
It'll just be
Now,
filled.
but there's other people that can be creditors can be executors of an estate. Now, I'm not suggesting a creditor, but I'm leading up to something I want to say.
Yeah.
And I want to preface it with this.
Yeah.
When somebody dies and they owe money to somebody, those are the creditors. And the creditors have 12 months after death to their rights are cut off at 12 months after death. Okay, and you see in the newspaper whenever there's a probate open, there's notice to creditors, right? They get 120 days to file a claim, and so what you cannot do is, and I've had people say, well, I'm just going to sit on this, and then after 12 months I'll open the estate, and that way the creditors are all barred. Well. Sounds like a good thought in theory, but it doesn't work because right at about 9 months, if you have a significant creditor, now if you have somebody that you owe $100, they're probably not worth their effort to go after it, right? But if you got a serious creditor like a hospital or air evac flight or something, about 9 months into that 12 months after death. Okay, remember, this 12 months is triggered from the day of death. And at about 9 months, you'll get a letter from them. It pretty much says this: if you don't open an estate, we will.
Yeah.
And you're thinking, who the heck are you to open my dad's estate? hey, a creditor can do that, and they often get appointed the executor when they do that.
Interesting.
Because they have a vested interest. Now, they're not just going to open it and take all his money. They have to do what the executor does.
Right.
And their reasons for doing it are self-serving, so their claim gets paid. But if there were other claims and that, they have to deal with all that.
They have to deal
now,
with all of it.
is that a good person to be doing your dad's estate? I don't think so, but it can happen. Now, what I'm leading up to is there are, and the names of them escape me, there are organizations that are professionals that do things like executorship for wills.
Right.
I know we have organizations that do the trusteeship for things like special needs trusts, and so there are people that are professional people that do that. You can hire them to do it.
Yeah.
Now, again, there's no personal touch with any of that, but they'll do what the will or the trust says to do. I mean, that's their job, and and you hire them to do it. So they, you're paying them to look out for the person's best interest. Just like when you hire an attorney, their job is to zealously represent. So the same thing applies. So if you don't have anybody to name, the last thing I would do is leave the will vacant.
Yes.
Void an executorship. I would name an executor, and I'd find some professional organization that would do it.
Yeah.
Or my first choice would be find some friend or acquaintance that would agree to do it.
Right.
And then name as a second or third the professional group, because you're never going to run out if they're the last one in the chain. So if these people if you do find somebody to do it, and they pass away early or before you, then you're always going to have one that exists because of the professional organization. So, that's a tough call. I mean, maybe the next best thing is go out and make some friends. I don't know. I mean, people in your church might be interested.
Yes.
To help, because it's people that would be helping out.
Well, someone you feel like would carry out your wishes.
That's right. That's right.
And that's what happened with my friend. He knew that this person would carry out his wishes, and appointed him to do so. And that person was honored to take it on.
Yeah.
And it just
And
worked out.
it's not a huge job, but it is a job. And in probate, it can be a frustrating job for them.
Yeah.
But like the successor trusteeship, what we do mostly with trust, it's not that daunting of a task.
Well, if it's spelled out what
That's
the
right.
person wants,
That's right.
I think that's the key to this, and what you and I have been talking about, and you bring to the table and have since we started, is that this is something that can be addressed, and it's so much easier and better on everybody if all those decisions are made ahead of time.
Mm-hmm. How do I know your wishes after you're gone?
Yeah.
But for if you had memorialized them somewhere,
Yes.
that I can go read them.
That's right.
And other than that, or maybe I guess you could make a tape recording or something.
It just makes so
but
much
still,
sense.
It has to come from you.
Yeah.
And unfortunately, at death, it can't come from you anymore. So it has to be reduced or memorialized in some kind of an instrument so
Right.
that you can pass it on
Right,
to people.
exactly.
I guess you can just verbally make it known to. We talked about that once.
Yeah.
I think that was a question that Ed brought up over at WKSR. When it was,
Right.
if you just verbalize it, make sure everybody's crystal clear. That's a way of making your wishes known.
Yes.
I think it's better to put it in writing because it has less misinterpretation that way.
That's right.
In my opinion. So when you express something, it's clear.
Yeah.
And don't be ambiguous either. I mean, when I say ambiguous, you might want to say, if you just say something like, "Hey, I'm leaving all my collectibles." The word collectibles kind of, maybe you know what Dad means when he says collectibles, but that's a term that's wide open to interpretation.
Yeah.
And now your heirs are going to say, well, wait a minute, that's not part of his collectibles. That's something outside of that. No, that's and you can it just be a little. You don't have to get hyper technical, but be a little
Right.
more specific.
Yeah.
Stuff like that.
Yeah.
Because everybody's got their stuff, and it's different for everybody, and the stuff that is important to them or something they really want to pass on to people. I had somebody say, all the furniture that I made goes so and so. Well, that might be figurable outable, for lack of a
Determinable.
term. That might be to establish what that is. You may be able to know what furniture Dad made, but maybe not. You might want to make a list of that stuff.
Yeah.
So anyway, it's always good. And again, that's the whole idea when they talk about estate planning or some kind of planning. The word planning just means you do all this stuff during life and you need to do it not just during life. You need to do it when you're of sound mind and can do it.
Absolutely.
You don't want it. Once you become incapacitated, then there's very little you can do, if anything.
Yeah, that's true. That's true.
And that's when you really need the people looking
Right.
out for your best interest.
Right,
That's when you
absolutely.
really, really need it.
Yep.
Yeah.
Yep.
So, and like I don't know if I mentioned this or not, but I think I did off the air. Got a wedding in my family tomorrow.
That's correct.
I don't know if I brought it up since we were on the air or not. We were talking about
Yeah,
it
I
during-
think we did. We talked about it a little bit.
Oh, that's right, we did. Anyway, those, this is the kind of thing both in my life as well as in my son's life that is thought provoking from a planning standpoint.
Oh, yeah.
I mean,
a
I
life-changing
I
event.
just had my second grandchild back in December. I mean, my daughter and the two grandchildren are at the house visiting for the wedding and stuff. So this provokes me to give some thought. I've got a new daughter-in-law now, and so my own planning a little bit. But if I look at it from my son's perspective, or somebody getting married, I mean, you know what that does to somebody. You get married, and all of a sudden, if you're laying in bed at night and you're just alone with your thoughts, and you think, I have people now whose lives depend on me.
That's
they're-
right.
Pretty much their very lives, the wherewithal, me taking care of them. At least with the old school thought that I've got, I'm the husband and I'm the one that has to take care of the family. It's my
Right.
responsibility, financially as well as health wise,
Absolutely.
as well as protection wise, and it's a wonderful thought, but it can also be somewhat of a scary thought.
Sure.
You know what I mean? So when you have a life changing event like somebody getting married, it promotes this thought about how, if I want to do this protection. Sure, I can do it now while I'm alive. I can do stuff, but what if something happens to me? I still want them protected.
Yes.
And so that's the kind of thing that these events is what gets the old brain matter going and thinking about this stuff. And it's and that's when we need to do it. That's when we need to do something. Now they're young. They're just just in the very early 30s.
Yeah.
So they're very young, but. And to complicate things further, I mean, they just bought a house. It was funny because they had a house that they've been looking at houses forever, and they can't get what they like. Finally found one they liked,
Yes.
made a bid on it, it got accepted a week before the wedding. And I said to my wife,
Oh, my
They,
gosh.
they really needed this a week before the wedding, right? Because now you have 3 days to have it inspected, you have 7 days to get some, it's just...
That's what you call piling it on.
It's got a list of, its own list, it's all by itself. And so it's like, okay, we needed another bunch of things to do. But, what do they say? If you make it through that kind of stuff,
Yeah.
you're all the stronger. So,
That's right.
So anyway, but, now, so he's getting married, doesn't have children yet, but I know they probably will very shortly.
Yeah.
And got a house, big investment, right?
Yes.
And so, he's got a reason to plan.
Yeah.
And I will remind him of that.
It's all the things.
I won't pester him, but I'll remind him of that.
Yeah, you would. And maybe you could recommend someone to go to.
Yeah, right. Well, it probably shouldn't be me. For my own kid, I know I would dictate the terms too much.
Yeah, I understand. But life is happening every day, and there's all these things that we need to think of, and sometimes you need help to get them thought of.
Oh, absolutely, absolutely. And we could just write a book on the things that just come out of nowhere. This, anybody can say, here's my plan, here's my goal for life. I'm going to do this, I'm going to do this, I'm going to do this. But the stuff that intervenes, that you never see coming, it just it amazes me sometimes. The
Yes.
stuff that can happen.
Oh, my
right?
gosh,
I mean,
the
it
stuff.
just is incredible. I had somebody who, actually, this was kind of a good story in a way.
Yes.
They had one of our asset protection trusts, and they had a lot of property in there and stuff like that. And somebody in the family had a very bad accident.
Oh,
and,
my.
and it was kind of their fault. I won't go into the details.
Yeah.
Not kind of, it was definitely their fault.
Oh, yeah.
And so a lawsuit's going to come.
Oh, my.
And when the dust settles, I would be surprised if it didn't. But they called and we talked about it. And I thought, well, we have this asset protection trust. We got this property that that is protected. And that's kind of what it does. Most of the time we do this to protect it from the creditor of long-term care.
Yes.
But long-term care is just a creditor. A creditor protection trust. A creditor protection trust protects from all creditors.
I hadn't thought about that.
Yeah.
I hadn't thought about
10 care is just one of them.
Yeah. So if you have an asset protection trust, then it can protect you or your belongings or things that you put in the trust from maybe some personal lawsuit or something like that.
It's exactly what it does.
Oh, wow.
Now, and one thing about that is you got to remember you can't do one of these trusts and defeat a existing creditor.
Yes.
So let's say somebody sued you and has a judgment.
Yes.
You can't say, okay, I'm going to him do want to stay on Mr. Stan's trust and protect my property so they can't get at it when they
Right.
try to affect the judgment. You can't defeat an existing creditor.
Right.
You can defeat future creditors. And future creditors, the biggest future creditor you're ever going to run into is long-term care.
Yes.
But if something like that happens, I often say as an example, if you have an automobile accident and somebody sues you above your policy limits,
Yes.
you have exposure, right? Well, that exposure, it doesn't go away. They're still suing you, but they can't get the assets that are in your trust.
Yeah.
That is beyond them because it's an asset protection trust where we've limited our access to the principal, and we couldn't get at it to give them to them if we wanted to. It's just the way it's designed.
Yes.
And so that's protected. Now they can go after what else you have that's not in the trust, but they can't go after the trust. And usually we put our big ticket items in the trust, like our real estate, our investment accounts, the things we really don't want to jeopardize.
Right.
Now, if all they can do is go after something else, then it's harder for them because there's less there. You know how when people sue, they talk about going after the deep pockets. You know, well, insurance companies the real deep pocket, and so usually when things like that happen, it forces people to negotiate a settlement within the policy limits.
Right.
It's a deterrent to the lawsuit, and it works.
Yeah.
And it works. I mean,
Interesting.
Again, when you put property in these trusts, you protect it from all creditors. Okay.
Yeah.
10-care is the one most people are worried about. But it is from all creditors. Now, another thing about that is 10-care is the only creditor, the only one of all the creditors that has that magical 5-year period.
Oh, yeah.
That we have to worry about.
Right.
Which means if you put property in one of these asset protection trusts today, Friday, and in Tuesday of next week you have this automobile accident and somebody sues you, that you're protected from them immediately the day we put it in.
Oh, wow. Yeah.
10-care, has this. And again, when we put a property in this trust, 10-care can't get it immediately. But what they can do is impose that penalty period that they can do for 5 years. So that has nothing to do with the trust. It has everything to do with the 10-care Act. But it has an effect on us as well. So, but like I said, all the other creditors, it's immediate protection.
Yeah.
I have some people that do my asset protection trust not because they're concerned about long-term care, because they have like 5 rental properties, and they're worried about getting sued at one of those rental properties. Now, you could do the same thing if you, well, not in an LLC. If you put it in an LLC, you can always sue for the LLC's assets, right? If you're an LLC and you sue, you can go after what's in the LLC. You just can't go after the personal assets. And the rental properties would be in the LLC.
Right.
But if you put these properties in this trust, they can't go after them. And so that's it's funny because sometimes I have several clients that have done it from that approach, and we get to talking about it, and they think, oh, you mean, and then after a couple of years, I'll have protection from long-term care as well?
Yeah.
Because most people come at it with the long-term care in mind.
Yes.
They come at it with not that in mind at all, just creditor protection in general.
Interesting.
And they thought, oh, what a good afterthought, a good after effect is, I've just been there for a few years, I'll be protected from that too.
Yeah.
So, yeah, I mean, it is immediately a creditor protection trust.
Interesting.
And again, like I said, it has to be a future creditor. It's self-serving to defeat an existing creditor by just saying, I owe this person money, I got a judgment, I'm just going to hurry and put it in a trust and then tell them to go pack sand. I mean, you can't do that.
Won't work that way.
No. That is self-serving. The court will not allow that. But if you do it ahead of time, it's not, because it's an unfair tort against the person that has a judgment against you to do that. But if you don't have everything going on right now, which is most people don't, it's okay to put it in. Then if it comes down the pike, we are postured with the full force and effect of the trust law and the creditor protection behind us.
Yeah, just another reason to not put this off.
Yeah.
Another
if you
reason.
come to me, I had somebody come to me that actually got sued. It was like a $250,000 judgment, and they were asking about this, and I had to tell I told them, I said, look, this will not prevent that.
Yeah.
It will not help you with what you're trying to do.
Once you've been in.
And he kind of said, well, I didn't think so, but I just wanted to make sure, and there's something I couldn't do. He was struggling to.
Yeah.
I mean, if you get sued, you usually get sued for a reason, and typically you probably should have to pay it. But,
Right.
But when we talk about 10-care, we don't want them to be a creditor because we've already paid for it. We don't want to pay for it a second time.
Right, exactly.
Yeah.
Exactly.
So, anyway.
Well, in the few minutes we have left, I want to remind everybody we're talking with Stan Pierchoski, Pierchoski Law in Pulaski, Tennessee. And, of course,
Estate
Plan Stan. That's right. Check that website out, estateplanstan.com. That's an easy way to find him. And of course, he is located on the square in Pulaski, Tennessee. And that phone number of yours, Stan, is what?
My phone number at the office is 931-363-7222.
That's right.
Or like you said, estateplanstan.com. Go to my website. Got a lot of good stuff there to read. Got my calendar. You can see where we're going to be. Have my phone number if you want to call and ask a question, or schedule a call and ask a question, or shoot me a question by email.
Absolutely.
I will answer them. I do them as jiffy as I can. But I will respond to all of those. And if it's phone calls, like I said, we schedule those. The girls will schedule them when I have an opportunity to devote my time and attention to the call.
Yep.
And if you go to the calendar, you'll see where we're going to be.
Yeah.
I'm pretty sure it's on there already that we're going to be here at WLX in the back of the building.
I was going to ask you about that again.
Yeah. On, let's see, what's March? It's going to be May the 18th, which is a Saturday. So those are at 10 o'clock in the morning. And we probably, I don't know that we'll even be in Lawrence County again for the rest of the year. Maybe one more time in 2024. Because then we go to other places. But, you can always come to one of the other places. I had somebody yesterday that lives in Pulaski and came to my office for their family vision meeting, and they were from Lawrenceburg. They came to the one over here. No, they were from Pulaski, but they came to the one over here and wanted to engage. So, Pierchoski Estate Law, Pierchoski Elder Law, that's what we do. That anything we talk about piques your interest and you want to talk to me about it, give us a call, 931-363-7222, or call me and ask a question. I'm more than happy to answer. I love questions.
The seminar is certainly a good idea, and that's May 18th again at 10 a.m. It is a great place here to have it. Plenty of room, and you'll learn a lot. I have learned a lot. I've enjoyed our conversations, and it's really brought a lot of things to light for me to think about and to do. And some of these things I've already got in place, but still, I end up learning something just about every day. We talked about those terminologies with the executor, and the executrix of the will. No will, you get an administrator.
Yep.
So I'm learning, and then with a trustee, you get a successor trustee.
Mm-hmm.
So we will be grading you.
That's right. There you go.
We will be grading you. Take a test after a while. Yep. No, that's pretty good. I'm enjoying the learning process into all this, and it's just knowledge is good.
Knowledge is good. I mean, I'm a big fan of education.
Yeah,
so
absolutely.
It helps. So.
Can help you down the road and help you with your estate planning. And we encourage you to call Stan Pierchoski Law.
Yeah, come to the seminar. I think you'll like it. The last one we had was over at Star Theater in Pulaski, and I had quite a few people come up to you afterward and said that was a lot of good information. They had learned a lot.
Good information. Well, it's always a pleasure. And listen, you got the wedding this weekend?
Yep, if I can live through it.
It's tomorrow? All right.
It's a joyous event, right?
Well, God's blessings on the
you.
wedding and your family, and I hope you just enjoy it.
Thank you, Jeff. It's always a pleasure on Friday morning.
All right. See you again soon.
A new attempt at the United Nations to stop the war in Gaza. I'm Dave Anthony, Fox News. This time the U.S.